Hi, everybody. Welcome back to the 10th of an Hour with Griffin Bridgers. For today's episode, episode 37, we're going to reprise a previous discussion about who gets your kids. This is all about the naming of guardians for your children. And for today's part two discussion, we're going to dive a little bit more into some of the specific documentation issues in terms of legal documents that can be executed and what effects those have, especially across state lines. So, I'll introduce our subject matter and then I have a bit of an announcement towards the end of this, but for the time being, I want to remind everybody that this presentation is not intended to substitute for legal or tax advice. So, going back to episode 13, as you may recall, we discussed ways in which you can name guardians for your children who would take over if one or both parents become deceased or incapacitated. So this could be a rare situation, but it's one that you want to make sure is covered as well. Now, the most common method for appointing guardians for minors is in your will. Now, a problem with a will is that it has to be signed under most state laws in front of two witnesses and a notary to be fully implemented or even changed if you want to change your guardians down the road. A lot of states also carve out that instead of just using the will, you can create a separate writing under which you may only need to sign in front of a notary to implement that guardian appointment memo or make changes to it as well. Now, the problem, as I mentioned, is that most people only name guardians in a will and not in a separate signed writing. And even though it doesn't seem like it should be, this can be fraught with peril. And there's some nuance to this, but we'll look at a case study in a second that could show where issues can pop up, especially when you cross state lines. And this could also be important in cases where multiple people, like siblings and grandparents, might end up fighting over guardianship because in that situation, if the court can't 100% rely on your wishes as expressed in a will, for example, then that may result in a guardian who you didn't want getting custody of your kids. So, a case study here is where we're going to assume that we have a client who lives in another state but wants to name a sibling in Colorado as a guardian for the client's two minor children. So what the client does is they get a will from an online service and they just simply name the sibling as a guardian under that will. Then the client dies and the guardian has to be appointed. But naturally what the guardian does is they get the client's children and bring them back to Colorado, and then they come to the attorney and say, hey, what do I need to do to get appointed? And in the meantime, the client's will is probated in their own home state, the will that has the guardian designations. Now, what happens? Well, there's a couple issues here. One is that the guardian wants to file in Colorado, but what Colorado law says is that a guardian designation in a will must be confirmed in the court where the will is probated or could be probated. Problem is here is that the client didn't live in Colorado, and if they had no property in Colorado, then the client's will could not be probated in Colorado. So in that case, you have to have a full manual type of guardian appointment where the guardian has to go in and represent that they have custody of the child and it's in the child's best interest, and a lot of people have to be notified. There isn't a streamlined process in this case for the guardian to get named as guardian for that child. So there's a lot of different issues and solutions, but they're so state specific we can't give you a firm answer. You end up down this big black hole or rabbit hole of issues that could go wrong, like should the guardian go file in the client's home state, or will the will hold up in the client's home state even? If it doesn't, maybe the guardian designation isn't even effective there. And another thing is, do the children have a right to object to guardianship in Colorado but not in their own home state? Because you have to get the child's consent sometimes at age 12, like in Colorado, but it might be age 14 in some other states. So that inherent conflict there as well could pop up if somebody wants to come in and contest the guardianship. So, long story short, any client with minor children should take advantage, where available in their estate, of the ability to name guardians through a signed writing instead of just relying on a will. So you're not subject to the probate process, and in an interstate situation, I should say, you don't have to have the court in the original state release like a certified copy of the will or do anything like that. You want to keep things as streamlined as possible, and this separate writing approach tends to lend itself to a more streamlined process in most states. Now, if there's a situation where client and guardian live in different states now, or in the future after any documents are executed, then the client and guardian should be aware of the different laws that could conflict, such as guardianship laws and even custody laws if a guardian gets divorced. And that's its whole own separate issue when it comes to who you should name as guardian among a married couple. And that's a discussion maybe for part 3. Now, even if there's an online will that has a section that names a guardian, one problem is that, even a perfect online form, if it can't be probated, this can avoid, or it could void the guardian designation. So one problem with an online will is that it can be imperfectly executed. So even if you pull a form off the internet, if you go get your own family members to be witnesses, then that document could be void because you have to have disinterested witnesses and a notary as well. And it tends to be easier to find those parties in a law firm and make sure that it's done right than it is to just kind of rely on a set of written instructions when it comes to finding witnesses. So, as I mentioned, somewhat of an announcement and a project that I'm working on is creating a free legal resource for forms to appoint guardians for minors. And these will be forms that are designed to, really just kind of implement state by state different laws. And obviously I can only speak to Colorado where I practice now, so initially this will only be for Colorado residents, but in the future it could be expanded out. But it's something that I think all parents should have, even if you don't want to go to the expense of getting a will or full estate plan in place. So be on the lookout for that in this channel and in my LinkedIn feed. But in the meantime, as always, if you have questions and topic suggestions, you can email those to me at griffin.bridgers@gmail.com. Thank you again for listening to the 10th of an hour, and I look forward to seeing you in the next episode.